Hi everyone. It's a Sunday. It's Republic Day. This is the first session happening in Kerala on like Republic Day.
Check,
I'm
check.
thankful for all of you who came here on Sunday. Gautam, let's start with it's a 76th anniversary, and Constitution is not a person, but my mother-in-law. I was just thinking aloud this morning. My mother-in-law is 76. I know it my bones that like she's too old to change. um, it's not a person, but what does age, how does age play a role in shaping this document? One obvious difference will be how some meanings that were interpreted by the makers get changed over time. After 76 years, after 50 years, after 100 years, those meanings will get changed. So, how do you think, what role does age play in shaping this document?
Yeah, as you said, today is the 75th anniversary of the Indian Constitution. And if you look at the median age of a constitution globally, it's 19 years. So constitutions tend to last for around 19 years, and then they are replaced in various ways. So already the Indian constitution is around four times the average age that a constitution gets to in history. And the short lifespans of constitutions are specifically, true for post-colonial countries, where either a constitution gets replaced at the point of a gun, or it basically becomes an appendage to an authoritarian ruler. It gets linked with the ruler, and therefore, when the ruler is replaced, so is the constitution. And this has been something that you have observed in constitutions in Latin America, in Africa, so in Asia. Pakistan has had three or four. The Indian Constitution, by any stretch of imagination, is has endured 76 years, and at least in part, and we can get into that in more detail. At least it's in part it's because the framers of the Constitution made a very flexible document, and by flexible I mean in two ways. One is that it is very easy to amend. So we have had in the last 75 years, we've had around 105 or 6 amendments to the Constitution. Exact number I can't recall, and that's an average of more than one amendment per year. By contrast, the U.S. Constitution, which is now 200 and 40 years old, has had 29 amendments. So that's your contrast. So in that sense, the flexibility of the Constitution that allows the political elite to frequently alter constitutional arrangements has also been a safeguard against the Constitution being abolished by those same political elite, and we can discuss if it's a good thing or a bad thing. The second is that even the framework the Constitution sets up for governance is itself a fairly flexible framework. So, I mean, the Constitution talks about parliamentary democracy, parliament, executive, but what exactly it means, there are no real rigid rules set out in the Constitution in that sense. So even governance, there's a wide range of governance features that are permissible within the overall constitutional framework. So I think that these are two reasons why the Constitution has gotten to where it is, and of course, like you said, the Constitution's flexible language allows for a range of interpretations to be advanced over the years that can, in a certain sense, keep up with the times. Now, again, you may say this is not a good thing because the Constitution's interpretation should not be subjected to changing times. It should be clear and constant. But this is the reason why the Constitution as a document still is, by and large, in many ways, structurally and by design, the same document that the framers crafted and gave to us.
You're right that there is a specificity and there is this wiggling room, but the same thing kind of got it almost destroyed once. We had an emergency where we suspended rights. Do you think that kind of a situation could emerge again, or have we learned our lesson from that and made probably this document more stronger these days?
Well, I mean, the thing that people don't often see is that, or talk about, is that Indira Gandhi's emergency was actually imposed following all constitutional procedures. So, under Article 352, there is a specific procedure to amend, to suspend certain parts of the Constitution, and that was followed, to the letter. And after that, the Constitution's amendment procedures were followed in order to bring about the 42nd Amendment, which led to a lot of centralization of power in the executive. Certain actions of the executive were challenged, and the Supreme Court, in the infamous habeas corpus case, the ADM Jabalpur case, which it gave almost a carte blanche set of powers to the executive, upheld those powers. Which again, the Supreme Court is a constitutionally constituted body, right? So for the emergency, all the procedures were followed. It wasn't an extra constitutional coup. It wasn't that Indira Gandhi suspended the constitution by decree. So in that way, I think the question that you should be asking, or we should be asking, is why was it so easy for that to happen? Why did the court fail? Why did Parliament? Why did the President, give consent so easily? Why was Parliament browbeaten so easily? Right. So these are all the questions that have to be asked about the structures that the Constitution sets up. Can it happen again? Well, two things. I think one is that because Indira Gandhi was politically defeated after the emergency, the declaration of an emergency now carries with it a political stigma. The people's verdict was against it. So it's a little difficult for future regimes to go the same path. But with that said, the other question is that do you need to go down that path? Because the Constitution itself has many provisions that allow for wide-ranging, unchecked executive power. There are many provisions of that kind. We are one of the only constitutions in the world that explicitly authorizes a detention without trial in the constitutional text, right? So do you really need to have an emergency when you can just use that provision in normal time, right? I think it is the question that should be asking on the 75th anniversary of the document.
Another thing that happens with the proceed of time is you have to encounter this new generation stuff. There's no social media when this was made, so you have to encounter this new beast all day. And right, you said amendments keep happening. We have at least one amendment a year or something. So, but you're a practicing lawyer. So how do you see execution-wise India is faring about encountering new things that were not there in the maker's mind? Now, also, if you could talk about, how the court application-wise, what's happening, when the Constitution has to meet these, strange new beats like social media.
Sorry, social media as in?
Yeah, in new ways, like when it meets like these things like social media, how it fares, execution-wise, how it fares.
Well, I mean, look, it depends a lot on again, how you interpret the text. Of course, the framers could not have foreseen something like social media, but the framers have put a free speech clause in the Constitution, and which is abstract. It guarantees the right to free speech and expression, and there are a set of restrictions that then follow. The question of social media then can be understood in that context. So, for instance, I was involved in this case last year before the High Court of Bombay, where some of you may remember this. It's still in appeal, where the government amended the information technology rules and brought in a fact check unit. Now, this fact check unit would be established by the government. Therefore, obviously, the government would have control over it, and it would flag content about the central government that, in its opinion, was fake, false, or misleading. And then the intermediary, say Twitter or Facebook or whatever, would either have to take it down or would then risk getting taken to court. So this is, of course, a very social media, specific provision. It's not something that was in contemplation when the constitution was framed. But when we argued the case, obviously you argue it on principles of free speech. So to give you an example, one of the major philosophical arguments against censorship is that the right thing to do is to have counter speech, right? So if I say something incorrect or fake or false or misleading, then the answer is not to censor me, but for you to say the correct thing and place the right point in the public sphere. So one of the arguments we made was that the answer to false speech is counter speech. And in fact, if you look at social media has certain structural features that allows for that. So for example, Twitter has something called community notes, right? Where underneath that tweet, you will have a fact check which is done by the community. Now, is it perfect? It's not. Often it can be misleading. But basically, I mean, you take your classic ideas of free speech, counter speech, and so on, and then apply them to the new world. And again, with the Constitution's flexibility and its use of these enduring principles, basically means that the task before the lawyer and the court is more to understand how to apply those enduring principles to a dispute. And while the dispute's contours may change over time, the principles remain, right? So that, and yeah, of course, where there is a change that is impossible to accommodate through interpretation, then you amend the constitution, which has happened, of course, many, many times.
Another thing is, as time moves ahead, there seems to be like a lot of these clashes keep happening. Like we are sitting in Kerala right now, and huge clash happened with the Sabrimala agitation. There's this constitutional code which said women can enter, but then the society and religious values said you can't enter. You are a keen observant of how these court judgments actually get practiced and what happens to those judgments. You keep writing, the kind of a review of judges when they retire. How do you see these clashes happening? What happens when the constitutional rights or the constitutional judgments, that clash with society and religious values?
Yeah, so this has been an issue that's been there throughout. And I think, it's interesting you bring up the Sabrimala case, because I think that it has a few lessons there. Because I think that the judgment was well reasoned, but that's a different matter. But if you look at the way the case came into being, if you look at the title of the case, right, the parties, it's Indian Young Lawyers Association versus Union of India, right? And in fact, the case was brought by two male lawyers who had no connection to the temple, right? And so what it became then was a kind of a top-down, imposition of a solution, which nobody likes, which people don't like, and then there was therefore a backlash, and ultimately, it became, and the state government ultimately, was not inclined to enforce the judgment. And so what we have seen, and this is not just true for India but across the world, is that courts can't force social change, right? If you already have a social movement, right, which is agitating for social change, which is being unable to achieve that social change through ordinary channels because those channels are blocked off for various reasons, and then that social movement comes to court, and then in those cases, the court can and should ensure that the rights of people are protected. So, for example, if you look at the very, very famous US case of Brown versus the Board of Education, where the US Supreme Court in 1954 outlawed segregation in schools, racial segregation, right? That was in response to, a civil rights movement that was, you know, quite strong and pushing for that. And even in that case, the southern states in the US were actually not enforcing the court's judgment. So finally, the president Eisenhower had to send in the army to enforce the court's judgment. And now, of course, it's segregation is illegal. But you'll need to have that kind of a contextual backdrop in order for courts to be involved in social change. So what I'm saying is that courts can't drive social change. They can be, and they should be, partners with movements in bringing about social change in a way that protects equality, liberty, and so on. But if courts try to just push it from above, then it becomes quite difficult if there's no support from the political establishment or movements.
Another aspect of this is the courts are like really important in interpreting and reinterpreting this document. And in our society, the judges are seen as arbitrators of justice. I'm curious to know, as a close observer of the system, what do you think about the quality of people who are coming in as judges in trial courts and all the way from trial court to Supreme Court? How do they interpret this document? I'm also asking this because I once worked on a very interesting story where one guy was given a death penalty by a trial court, and he was acquitted by the higher court. So you see, the same set of evidence went from trial court. It got death penalty, so it got referred to higher court. So the same set of evidence between one judge and another judge, it's a life or death situation. What do you think about the quality of judges coming into the system?
Well, I think there are two things that you need to keep in mind. I think one is that judges are never separate from society, right? Judges don't sit in an aloof ivory tower where they are, in a certain sense, immune from society. So therefore, whatever social prejudices that exist, will invariably be reflected in judgments. You won't have judges marching far ahead of society in that way because they come from society, right? And that's true for any country, any jurisdiction. More specifically to India, I think, and this is of course a big debate, is the manner in which we select judges, right? So presently, the selection of judges to the higher courts, the High Court and the Supreme Court, is through an organ called the Collegium, which is, for the Supreme Court, the 5 senior-most judges, and for High Court appointments, the 3 senior-most judges of the Supreme Court. Now, that is problematic for 2 reasons. One is that the process is completely opaque. So unlike other countries where the process is transparent, where people apply for judicial vacancies, where you have interviews with applicants, and where then finally you have selection, here you have absolutely no disclosure of who is getting picked and why. The second related point is that therefore, because you have so much concentrated power in the hands of the top 5 or top 3 Supreme Court judges, those judges of the high courts who are, say, broadly in the zone of consideration for elevation to the Supreme Court, will, and this is human nature, will start telegraphing, right, to the Supreme Court Collegium that, they are broadly in tune with what those people believe, right? So they will try and, signal that, okay, we are a safe bet, we are broadly in line with what you people think, and that's, like I said, it's a human characteristic, right? And that breeds a kind of conformity across the board that is quite damaging for a thriving judicial culture. It weeds out people, who will not, say, conform to, the dominant wisdom. Now, if you look at how judges are selected in other countries, you see a big difference. So, for example, in Kenya, which right now has a very independent judiciary, and that's something that is, it's a judiciary that frequently steps up and confronts the executive in high stakes matters. You have a judicial service commission. This commission has members from the bar, members from the bench, it has members from the public, it has representatives from the parliament, and these people all sit together, and the proceedings are public, and then they give a short list of names to the president who appoints the judge. Similarly, in South Africa, same process. So the idea is that you basically have this open, transparent process where all the stakeholders are involved in the selection process, but no one stakeholder has dominance over it. Right? So basically, transparency and the dispersal of power in the selection process are two things that seem to have worked well in guaranteeing a certain kind of independence in the courts. We in India lack both. And the problem is that people often make it an either or situation, right? They say, okay, either we have the collegium or we will go back to the old days of executive dominance of the Supreme Court, where Indira Gandhi would, like, supersede judges, transfer judges, and so on. And you want that. Now, of course, no one wants that. But it's not a binary. There are a whole set of institutional processes that you can put in place that is neither the collegium nor the executive, but there seems to be no political will for that. When the Parliament brought in the NJAC, the National Judicial Appointments Commission, in 2015, the first big act of the BJP government, that was actually bringing back the executive in through a back door, right? So it seems to be no real, political will either by the executive or by the court to collaborate on a system where you could actually ensure independent judges coming to the higher courts.
I'm curious about your thoughts on how the present government has handled what is protected to us from the constitution. It's a second term, and over a 70-year period, a two-term government makes a huge difference. What are your thoughts on how this government upholds the constitution?
Yeah, so I mean, I think there are two things here. So in constitutional terminology, we have this phrase called constitutional hardball, which I would call, say, constitutional bodyline balling, right? So a cricket term, where basically you keep pushing at the edges of what the rules allow and try to see what you can get away with, like in bodyline bowling, where you try and see, okay, will the umpire allow me to get away with this borderline, legal, illegal act? And if the umpire says yes, then you keep trying to, push the boundary every single time. So I think that the present executive, which is now in its third term, albeit with a coalition government, has really played constitutional bodyline bowling in that sense, because they've always tried to, and I mean, this is true for, again, any executive that is strong and has a majority. They have tried to push the boundaries of what the constitution allows. They have tried to advance their own interpretations of what they think the constitution allows, which is obviously always a little to the edge of what the established wisdom is, and then try to see if the court or if people push back. Now, sometimes people have pushed back, as in the farm laws, as in the CA and RCA protests. Sometimes people have pushed back. Sometimes the courts have pushed back, as in the electoral bonds judgment, which was, of course, quite significant. But by and large, actually, the courts have been quite, passive in that they have either refused to hear cases. So, for example, one instance of constitutional body line bowling, and this affects federalism and Kerala, states like Kerala, is the government's use of the money bill route to pass legislation. Because when you classify a bill as a money bill, then upper house, Rajya Sabha, cannot veto, cannot amend it, right? So they are out of the equation. And of course, upper house is where the states have representation. Now, the present government has frequently classified, using the Speaker's office, has frequently classified bills as money bills that have no relation to money bills at all. The Aadhaar Act was a money bill. That's what they did because they did not have the numbers to get it passed in the upper house. And the Supreme Court, since 2017, the case has been pending. So 8 years have gone by. The court has not heard, substantively heard the case. And you have many examples of this kind, where in these kinds of controversial constitutional cases, the Supreme Court has just not heard the case. They've just not listed the case. And so what do? Status quo benefits the government, and nothing you can do. And the other, of course, is when the court upholds the government's action, as in demonetization was one major case where the Supreme Court just put a rubber stamp on the executive, and Article 370 is another example of that kind of thing.
There are mixed responses also, right to privacy.
Well, right to privacy is an abstract case, right? It was an academic question. It is very easy for a court to declare in the abstract that there is a right to privacy because nothing is really riding on that. But when it comes time to apply that doctrine to an actual case, say Aadhaar, there the court actually says, okay, but restrictions. So I don't think that when the court, if the court is the court declaring that there is a right is not really very valuable. It's, can you apply that right to an actual case where there are high stakes, where the government is pushing back? Then can you still do it? And then if you can't, then that tells its own story.
I'm curious to know your thoughts about the state governments also. Like, how do you think they fare? We talked about the union government, but I think the state government is more directly accessible to the people. They are the first line of defense, and so many things. Like even the Shabarimala judgment, the state government is supposed to give the protection for what is constitutionally provided. How do you think the state governments, are they equally bad? Are they worse? Are they better than what is the union government doing?
Well, I think again there are two things here, right? One is that under India's federal scheme, powers are heavily skewed towards the center, and this has become worse over time. And again, the present government has actually really pushed that centralizing reading of the constitution. The GST being a classic example of that, right? The GST tax is one where you really take away the autonomy of states, to frame fiscal policy. And the other example is Article 293, which basically says that if any state government, any state is in debt or has debt, then the central government can impose further conditions on borrowing. In fact, state of Kerala is presently in the Supreme Court, has sued the Union of India because basically Kerala has argued that the Union of India is using this provision to basically try to enforce neoliberal policy on the states, and that's presently pending in the Supreme Court. So in that way, you're dealing with a situation where over the years, meaningful power has really shifted from the state to the center. That's one thing. But secondly, of course, I think that doesn't mean that states don't have powers. They have a lot of powers. And here, I think, again, you see that the issues with what is happening at the center are often replicated at a smaller scale in the states. So, for example, when COVID-19 happened, then the center basically invoked the Disaster Management Act, which actually is meant for earthquakes and cyclones and typhoons and so on. It's not meant for a long-lasting public health crisis. the central government invoked that act and basically began managing the pandemic through decree, passing all these decrees and without consulting parliament. And of course, it soon turned out that these decrees were, creating more problems. And so every 2 weeks, and you may remember this, every 2 weeks there would be a fresh notification, often rolling back previous notifications. The central government did that. The state governments did the same thing. So the state governments invoked the Epidemic Diseases Act, which is an 1895 colonial law, and used that to have this top-down management of COVID. In Maharashtra, they used that to basically seal off entire villages, which was quite problematic. In fact, Kerala was the only state, I remember this quite vividly, Kerala was the only state that actually passed a law to deal with COVID. No other state did so. So I think in that way you see, this whole executive-centric, top-heavy, style of management having an issue both centrally and at the state level.
But like you said earlier, this whole thing about pushing the envelope, trying to see if we can, do a little change on the constitution this way or that way, pushing it on the edges. State governments also do that, right? And these days, increasingly, when it comes to controversial topics like reservation and all, we see state governments, formulating a law which says 60% reservation, and then finally it gets struck down by the Supreme Court.
Yeah, that is just that it's a smaller scale, and often the Supreme Court is more amenable to pushing back on the states than it is the center because of a difference of power between center and the states.
The role of media, how do you think the role of how media is shaping the evolution of constitution? It's for better or worse, it's supposed to keep a check on these things. But what are your thoughts on the media today?
Well, I mean, the extent to which the media can keep a check on the executive and enforce or defend constitutional rights is dependent upon how independent the media is, right? And that's a ownership and structural problem, right? So you have, say, something like the Caravan, right, whose funding is not dependent on advertisements, is not dependent on the state. They can take a more independent line. Whereas if you're running a newspaper, which is actually dependent upon government ad revenue, to exist, or if you're running, a TV channel, where again, same thing, independence is compromised very easily. And of course, in Kerala, you had a situation where a TV channel was temporarily taken off the air by the government for covering the CAA protests. And then it was, so the court stepped in and said, restore that. So yeah, there are all these issues.
But do you think it's shaping, how the rights are interpreted? Sometimes the debates are really skewed on media, no? So how do you think that part, plays out? Because it really is about what the society thinks the rights are, and the media enables it. Media plays a huge role in it.
Yeah, I mean, the media plays a big role in shaping culture, and part of culture is, how a society conceptualizes rights and obligations. And I think, yeah, it's you see that in, for instance, whenever there is a big crime that's happened, the media always and invariably, what you never see is the media focusing on something like the presumption of innocence, or just the importance of due process, things like that, which are really fundamental to our legal system. In fact, the media often treats the accused as guilty, and then that of course will then shape how people think, So I think that's the big issue. That's the big problem.
There's this recent case of death penalty here, and you could see, I think even in Supreme Court there's a line of thinking that death penalty should be reconsidered. But as soon as the death penalty verdict is announced, you see the media celebrating it, glorifying it. It happens otherwise also. If the death penalty is not given, the next day paper will print that judge's photo and say, what a stupid judgment.
Yeah, I mean, I remember this couple of weeks ago, right? There was a death sentence, and and it was all in the media, Kerala media, and national media also.
There was this
So
case in West Bengal, and there was
West
a
Bengal,
judgment
yeah.
in you.
Yeah. So I mean, in fact, the West Bengal judgment actually is interesting because it is a given the amount of media scrutiny on a case like that, it is actually very hard for a judge and a trial court judge who doesn't have the protections that High Court and Supreme Court judges have. For a trial court judge to say, okay, I will block out, the entire media, trial, and I will ask myself, according to existing legal doctrine, does this case merit capital punishment? And the answer is no, it does not, under existing legal doctrine. So I think that was quite remarkable that a judge was able to, a trial court judge, was able to really, tune out the noise and apply the law and say, okay, even though the entire media apparatus is gunning for capital punishment, and this will make me very unpopular, I will still do it.
I'm curious about this what we just meant, what we had just kind of touched upon earlier in our discussion. This thing about how do our system fare against the global order, uh, from where it started to where it is now. Do you think we have like lessons that we can take from other constitutional democracies, other constitutions?
Yeah, I mean, there are, I think, always things to learn, and like I mentioned before, one jurisdiction that I study quite a bit is Kenya, and it's interesting because for around 20 years they had a de jure and then a de facto one-party state, where the judiciary was almost completely captured by the executive, and they were basically just a rubber stamp. They then, when they were able to move back to a multi-party democracy, they actually had a wide-ranging judicial audit where judges who were demonstrably biased or incompetent or giving all these pro-state judgments were replaced. They were removed. And every single judge had to go through that. In fact, the present Chief Justice of the Kenyan Supreme Court also had to go through that audit at that time. So they and now they have a court that actually is really standing up for citizens' rights and really facing down the executive. So it's very independent. In South Africa, they went through apartheid, where again, it was a well-known fact, and this is something that will have echoes, that if you had a case involving the ANC or national security, or a case involving of that matter, the presiding judge of the court would always assign that case to a very pro-regime judge. And you see that issue happening in India as well, right? Where the powers of the Chief Justice of the High Court and the Supreme Court to assign cases is coming under scrutiny because, judges always have ideologies, and judges could be more pro-liberty, they could be more pro-state, and therefore which judge a case goes before will often play a big role in deciding what happens in that case, and therefore who assigns the case becomes a big issue. So they had that massive problem, and then they got out of it, and again now they have a very independent court. So I think it's I think every country goes through cycles of judicial independence, judicial subservience. It goes in a cycle, and just seeing how other countries have gone through phases, I think, can always be helpful in figuring out what we do.
We discussed a lot of stuff. This. I was just when you were talking about the judge's appointment, I was just thinking that in the South especially, you see a lot of these constitution protection rallies these days. Yeah. It kind of it's that story when the teacher says ask the class to be silent. It often means that the class is not silent, but it could very well be the politicians playing a drama around it. But what do you think? Are we facing like an imminent danger that our public doesn't really know about or care about?
I think that so yeah, I mean, in fact, in the last election, right? This was a big issue where the opposition actually managed to get significant traction on the point that if the BJP or the NDA gets 400 seats, they will significantly alter the constitution and will, bring in various things and get rid of various safeguards. I think for me, what was really interesting about that debate was the BJP's response, which was that, we will not do any of this. We are as committed to protecting the constitution as anybody. And I think the Home Minister Amit Shah had this really, strange line, where he said that even if Ambedkar comes back today, he can't amend the constitution, which is a little weird because you've amended it like 103 times, right? So I think for me, what was interesting was that the BJP tried to out opposition the opposition in saying, look, we are the true loyal, constitutional soldiers, and you are the ones who have a history of mangling the constitution. And of course, you can argue that this is cynical and this is X, Y, Z, but that they needed to, do that, I think tells its own story. And for me, then, what is interesting is that how is it that everyone, across the board, seems very, very comfortable with the constitution, and I think that perhaps tells you that in some ways the constitution actually is not really an obstacle to any political party. Any political party with its own expansionist goals is actually very comfortable working within the constitutional framework. Is that a good thing? I'm not sure, right? Because the whole point of a constitution is that actually it should provide constraints. But if actually the constitution is not meaningfully constraining, these parties, perhaps that's what we should be more worried about. So I think less worry about will the BJP change the constitution, will they, alter it, and more why are they so comfortable with it, right? Like I think that's the real worry I have for me.
Kind of reminded me about, Yes Minister, that BBC show. It's Republic Day, do you have a wish list sort of thing on this day, that the changes that you would like to see in the short term and the long term, changes that will protect its stability, changes that will meet certain, modern day challenges?
Yeah, so it's interesting because when the constitution was being framed, there were actually other people writing their own constitutions. So there were 4 such attempts. One was M.N. Roy. He wrote what he called the Humanist Constitution. There was the Gandhian Constitution, written by Gandhi's followers, a Gandhian Constitution. There was the Socialist Party Constitution, and there was the Hindu Nationalist Constitution, which wasn't very, very Hindu nationalist, but it came from them. And I think that if you look at these 4 constitutional arrangements, what stands out is that most of them were 2 things. One is that they were a lot more committed to decentralization of power. In this big, heterogeneous, diverse, plural country, centralizing power will have problems, right? So they were committed to decentralizing, distributing power. And the second interesting thing is that they saw a much greater role for the people in constitutional arrangements, in administering the constitution. So in our constitution, we begin the preamble with we the people, right? And then the people are forgotten. They go off stage. You don't really see any other reference to the people. But these, constitutional visions, they talked about referendums, of the right to recall, of active public involvement in legislation, and so on. So I think that, what I would like to see, and I discussed some of this in this book, which is just coming out. I've just written it. The Indian Constitution, Conversation with Power, is that the constitutional arrangements should should reflect more the diversity of the country, in terms of federalism, in terms of, something like Article 370. Like, you have all these unique arrangements that reflect history, that reflect, the diversity of the country. One is that, and the second is a much greater role for people. You shouldn't be that, okay, once in 5 years or 3 years or whatever, the people vote and it's done, and they come back in 5 years. It shouldn't be like that. It should be a much more ongoing process. And other constitutions do that. So, South African constitution explicitly has a role for the people in, consultations for lawmaking. Latin American constitutions require free, prior, and informed consultation with people before you have these big industrial projects that, displace them from their homes. So there are these things you can do, which we don't have them yet.
We don't have the right to recall also. Something, and we'll wrap with this question. I think after that we'll open it up to audience. Something about your work. You write these long blogs about judgments, case studies, judges. Sometimes it's multi-part, like a web series. And I wonder what you think of your role is when you write these things, because it must be like very tough to have a practicing law career on this side and writing these things on the side, and you have a flair for storytelling. You explore that bit of you much more in your fiction work. What I felt as a reader, I felt it bridges this gap between what is happening to the constitution as a living document and the average reader's awareness about it. And you're doing it interestingly. There's a technology element to it. You're posting it online instead of publishing in an academic journal or something, so that we have direct access to it. We just have to follow your Twitter. I wonder, like, one, what do you think your role is while you do it? Second, how do you manage to get the time and discipline to do it? Because there are not so many people who are doing it right now.
Yeah, I think the role is to demystify the law, because law is often mystified, the vocabulary, the language, all of that. And secondly, to democratize, the law, right? So to make it accessible for non-lawyers, public facing, basically, is the idea. Because again, what happens in court is often really, away from the public eye in many ways. And again, the thing is that if you look at other countries, there is what you see in the final judgment is what the court has said. In India, there is so much happening, informally in the court, interim orders, stays, a stay given, lifted, all of that, and actually hugely consequential things, So the whole election commissioners, case, when the government, took back power to appoint election commissioners, no judgment has come out yet. But you have these interim orders, that actually benefit the government by not taking action. And so, yeah, to try and break that down, and that is very hard unless you're an insider, and unless you're familiar with the way the court works on a day-by-day basis. And that only insiders can do. An outsider doesn't have the equipment to do that. So I think, yeah, sort of using my insider position, which is obviously a position of privilege, to try and demystify and democratize the law is, I think, the goal, that I have when I do all this.
And how do you manage time to do this? You write at night or something.
I mean, you just have to find those little snippets of time, slivers of time, and just use them well, and then that's how you do it. There's no rule to it. It's just, yeah.
You make it sound easy. It's no big deal. So with that, we'll close the session and we'll open to the audience. Please raise your hand if you want to ask a question. Waldia will reach you with the mic.
Recently, there was a Supreme Court judgment. As a Supreme Court judgment that laws do not come under the purview of the Consumer Act. Recently, so what is your opinion on that? And secondly, if that is so, where would a common man would go if a lawyer cheats him?
Yeah, so I haven't read that judgment, so I don't really have a strong view on it. But to answer your second question, normally you would have a standards body, right? Like so, the bar council is the body that should be the one that gives you a remedy, because like any other industry, there is a regulatory system in place, and the bar council is the one with the power to take action against lawyers who act unethically or who act in a bad way.
We have only 15 minutes for questions, so let's.
Morning, sir. I must congratulate you for bringing the constitutional nuances accessible to us, all of us, for whom they are meant. My question is that in today's India, when every institution has been sort of turned into a instrument for the executive and the ruling executive to propagate its ideology and has been weaponized. Also, the courts, the highest courts, have been weaponized to subvert the dissent. What is the hope you have for peoples of India for their freedom, and especially for the people who have differences with the ruling dispensation? Thank
Well,
you.
I think that the one thing is that no institution is a monolith, right? So, and Supreme Court as well. So you will have frequent bad judgments. You will have judgments which strengthen executive power, that undermine rights. But you also have judgments that sometimes go the other way. So in that way, it's not like a Stalinist system where there's no light at all, right? So there are always little cracks you can push on. So I think one thing is that, and second is of course that these are, like I said, these are all cycles, they are all phases, right? So there is again going back to Kenya, there is a famous example of this Kenyan lawyer called Firoz Noroji, a Parsi lawyer, because you had the whole migration there. And in the depths of the one-party rule, he would bring all these cases, and people would say, why are you trying? Obviously, you're going to lose these cases. And he would say that we are doing it for the record, because nothing is more important than having the record, because when the cycle turns and passes, you need to have the record in place to then, build on that. So I think that even when there is a situation where it's very difficult, keeping on building the record and doing it for that, I think has its own value that we engage in. Yeah.
Gautam, I have a specific question actually about Babri Masjid,
Yeah.
that particular judgment, which was a little bizarre in the sense that on the one hand, the Supreme Court said that the destruction of the Babri Masjid is a criminal act, right? On the other, it allowed, bizarrely, Ram Lalla as a plaintiff, right? And then it became Ram Lalla versus the Waqf board, right? Yeah, so it's, how does that actually even happen? I mean, how can Ram Lalla be admitted as a plaintiff, A?
Yeah.
B, when the destruction of the masjid is declared a criminal act, then how can the temple be constructed on that land, which was, yeah.
Yeah. So on your first question, this is one of those completely, strange things about law, and this is an inheritance of the British common law, where you have or you assign legal personality, to non-persons. So corporations, right? Corporations can sue and be sued in their own name. And way back in the colonial era, the British basically allowed this to happen, where you can bring cases on behalf of gods. So that's an old thing. It's not a new thing. So it's quite old. Your second point is interesting, because and this is a point that Suhrit Patsarthi and I made in our piece in the Hindu, when we said this judgment is basically is completely flawed, which is that, okay, look, either you say that this is purely a property dispute, right? And we will decide the case purely on property law, right? Or you say this is a larger political issue, a criminal case, and we will, decide the case on those grounds, right? The Supreme Court tries to do this weird balancing act where it says, okay, we are deciding the case on apparently property law grounds, but also commenting on, like the broader criminal act, which then is neither here nor there, right? So you do one of the two. So I found that quite, it was your Supreme Court trying to please everyone, basically, right? Saying, okay, we will give the land to, like, the Hindu side, and so Ram temple can be built, but we don't want to come across as ignoring what happened. And so we'll also do this thing as well. But, like, yeah, that basically made it a neither here nor there situation. And nobody finally, was convinced by what they did. So, yeah.
Hi, sir. Sir, the Constitution is known as the living document, right? So, what makes a Constitution live so long? Is it the constant amendments, or is it the drafting, or is it the belief of the people in that particular Constitution? If you say that it's the drafting, a well-drafted Constitution of Pakistan didn't last long. So, what do you think makes the Constitution live long? And my second question is, do you believe that the people should have the right to recall the MLAs if they are not performing well? If so, who would publish the report card for these MLAs? Because if you look at the media, most of the media is biased. They are either standing with the opposition or either with the ruling party, because most of the media is owned by the corporates, which is held by these political parties in power. So, what's your take on that?
Yeah, I mean, what makes the Constitution last, I think, compromise, right? So, and you can say it's a good thing or a bad thing, but ultimately a Constitution that compromises between various interests and does not antagonize any interest, I think, is the one that lasts. The Indian Constitution, for example, it could have been revolutionary. It could have brought about large-scale land reform off the bat. It did not. It actually had property protecting rights, right? So yeah, and it's lasted, right? So again, you could be a good, bad thing, you could like it, dislike it, but ultimately, yeah, a compromised constitution is the constitution that actually lasts the longest. The second, yeah, recall. I mean, it's a good idea in theory. And in fact, K.T. Shah in the assembly wanted a right to recall. Ambedkar wanted a right to instruct, but I think you're also right in that there are perils. So if you look at the US, certain states, California, have recall provisions, right? And they're actually been misused because what you've seen is that organized right-wing pressure groups have mobilized to invoke the recall provisions, and then get progressive people recalled. So yeah, I mean, a lot will depend upon how you structure these provisions, how you and what is the ecosystem within which they operate. And that will determine if they are successful or if they become, again, weaponized to serve partisan interests.
Fascinating discussion. Thank you very much, Gautam. From me, two quick questions. One is one of the most, in my view, one of the most fundamental constitutional judgments since the independence of India, protecting our constitution, was that of the Keshavananda Bharati case, which actually originated in the state of Kerala. There have been noises in the recent past that needs to be revisited and the basic structure of the constitution should be readdressed once again. What is your view on that? Do you think that will come to bear? Because that will have significant impacts on the constitution. Second, I think legendary legal people who have had the best of intellects in our country, people like Nani Palkiwala, people like Fali Nariman, I think the younger people of our country are losing track of what they did and the arguments they brought to bear. I do believe that there is space for those stories to be retold to young India.
Yeah, I mean, so on the first thing, if you look at the 50 years since Keshavananda Bharati, the doctrine of the basic structure has been invoked or deployed by the court to strike down amendments a total of seven times, out of which 6 of those 7 times were the court protecting its own turf. So the doctrine is it's a very powerful rhetorical tool. The doctrine, right? Like that we have certain enduring, immutable principles that underlie our constitutional order, democracy, rule of law, secularism, and so on. Right? Has it actually stopped any political project that was powerful enough to have its way? It has not, right? So you can say that secularism is part of the basic structure. What does that word mean? You can interpret that word in many, many ways. In fact, you have the Supreme Court itself saying that Hindutva is, a way of life and therefore not, contrary. So yeah, I mean, you can interpret anything in any way. So I don't think that if there is an attempt to, fundamentally alter the political scenario, I don't think that a doctrine can really stop that. So I'm not that concerned about it because I don't think it matters that much. Yeah, and the other thing, I think there's always a scope for telling these stories, and specifically, people standing up to powerful state and using law as a tool to do that. So I think, for sure.